Well, good morning, everybody. Welcome to our Trust Talk. Contrary to popular belief, I'm not Sam Scaife. I'm Joanne Francavilla with BBB, and I'd like to take this opportunity to introduce our speaker today, who is Bill Thrush. He's the managing principal at Friedman, Fromme & Thrush, a law firm. He's a member of the Board of Governors for the Commercial Law League of America. And we are very lucky and very proud to have him as the chair of our BBB Maryland Foundation and a member of BBB's board. In addition to that, in his spare time, Bill is an outdoor enthusiast and an avid mountain biker and snowboarder. Where he finds the time to do that, I don't know, with all the other stuff he does. So today he's going to talk about some of the challenges that small businesses encounter in collecting their accounts receivable, especially in the economic environment that we're all in now with the COVID-19 shutdown going on. So I'm going to turn it over to Bill. There's a chat box. If you see that little bubble on the top of your screen, if you have any questions as Bill's presenting, you could type them in the chat. We'll be monitoring that throughout, and we can have those answered either during or after the presentation. So take it away, Bill.
Thanks, Joanne. Thanks, everybody. Good morning, almost afternoon. I'm Bill Thrush. That's me there. And what we're going to talk about today is managing your accounts receivable in the post-COVID world. And the way that we're going to approach this is we're going to look at it from three different phases. We're going to look at before the client relationship begins, once the client relationship has started, and then once the account goes bad. So let's dive right into it. Let's talk about before the customer relationship starts. So the first thing that you're going to want to do is do your due diligence about your customer. Before you enter into that relationship, do some homework. How do you go about doing that? There are a number of things that you can do. One of the most important to do is that number one bullet point there. Check the status of the organization, particularly in Maryland, but in other states throughout the country. There's a website, the State Department of Assessments and Taxation, SDAT, S-D-A-T. If you log into the Maryland SDAT, and if you just go and Google search, you put in Maryland SDAT, it'll come up. It'll be the first thing that comes up. You can do something called a business entity search, where you can put the name of the business into that website and pull up all of its corporate information. You can find out who the resident agent is. You can find out who the principals are. You can see some of their corporate filings, but most importantly, you can find out what their corporate status is and make sure that their corporation is in good standing. The other thing that you can do is check their Dun & Bradstreet report to check their credit worthiness. You can ask them for bank references. One good thing to do is look them up on social media. Social media is just an absolute gold mine in terms of information about your client or your customer, and not just their corporate page, but if you know who the principals are, see if you can find them on social media as well, because you'll get information about what kind of person they are if you don't know that already. And then finally, a lot of companies will have financial statements, particularly if you're extending credit to this customer. You're going to want to get that financial statement just to see if they are, credit worthy. You're making an investment in them. You want to make sure that that investment pays off properly. So here's the second thing that you're going to want to do is create a policy for receivables. This is really, really critical to setting up your business, particularly in the post-COVID world. To have a policy laid out, a firm policy laid out as to how you're going to handle your receivables. Why? Well, it sets the expectation, right? And that's the most important thing, is setting the expectation. Everybody knows right from the get-go what the relationship is going to be like. Everyone is put on notice as to how your accounts are going to be handled. So what's the benefit of doing that? Well, you set the expectation early, and so if it goes sideways, and statistically speaking, some of them will, it'll minimize the strain on the relationship. So you'll be able to refer back to the policy and say, well, look, this is our policy. Our policy is what it is. And it's easier to turn it over to collection as well, which I'll get into a little bit later, because it's business. It's not personal. I know that sounds a little bit like a cliche. Particularly you see that a lot in Hollywood, in the movies. People say, it's just business, it's not personal. But there is some truth to that. If you make things business related, you keep things at an arm's length, it makes it a little bit easier to chase those receivables. So the next thing that you're going to want to do is you're going to want to update your old forms. If you're using forms that are 10 years old, you've been using the same forms for the last decade and a half, your forms are outdated. I mean, they just are. Think about the things that existed, that exist today that didn't exist 10 or 15 years ago. iPhones, Twitter, stuff like that. I mean, the world is changing, and it's changing very quickly, particularly in the post-COVID landscape. The way that we're going to have to do business moving forward is going to change and has changed dramatically. So examine your forms. Make sure your forms collect the right data for you. Social security numbers, dates of birth, bank account information, all of that stuff is going to be absolutely critical to collecting your accounts receivable. And I'll tell you why in just a couple of minutes. That next bullet point there, think about what you need not just on the front end to establish the credit, but on the back end to get exactly what you need. Make sure your forms reflect your receivables policy clearly. That's going to be the real issue, is to make sure that you have absolute transparency in what you're doing. Don't fine print that policy. Don't make it little teeny tiny type. Make it really obvious, so that everyone knows right out of the gate the expectation is set. Next, a credit application. If you're going to be extending credit to your customer, you're going to want to use a credit application. This is a very, very useful form because you can collect a lot of information from your customer, bank account information, and some of that other information that I talked about on the last slide, the social security number, the date of birth. You can collect address information. All of that could come in handy a little bit later. The next thing that you're going to want to consider also is a personal guarantee. If your customer is a business, you have to understand that a business, from a legal standpoint, acts as a separate individual. Even if that business is owned by an individual, that business entity gives that individual their assets a certain amount of shielding. What you want to do is be able to what they call pierce the corporate veil and get access to that individual's assets. That's what a personal guarantee does. That is to say that if I own business, company A, and company A owes money to you, I guarantee that I'm going to be liable for anything that company A owes you. It's just another way to make sure that you get your debt collected. Here's a catch though. It's got to be conspicuous, and you have to clearly define the individual's responsibility to pay. Again, transparency. Transparency is the key here. Make sure also that you have a clause in that credit application that allows you to collect reasonable attorney's fees. If you have to hire legal counsel later to chase this money, you want to be able to get those attorney's fees paid for. Next, don't forget to include interest. You're entitled to it if you put it in there. Most places put in a 1.5% per annum from the date of default. But again, transparency, like everything that we do in business, transparency is key to building the trust relationship with your customer. So make sure that it's clearly and specifically stated in the credit application. Okay, so you've landed the client, right? And you're ready to get going. What do you do now during the client relationship? How do you tell them that they're past due without upsetting them, right? That's the eternal conundrum, right? Somebody owes you money, and just the act of telling them that they owe you money is going to upset them, and it could ruin the relationship. Well, stick to your policy, because remember, you established that policy very clearly in the beginning. So they knew what they were getting into. They've got no reason to be upset with you if they knew what they were getting into, and all you're doing is enforcing the policy that you set out and they agreed to. Second, you may want to consider working with an attorney to craft a form letter. If you yourself aren't a crafty wordsmith, work with an attorney to craft a form letter that strikes a proper tone. You're going to get more flies with honey than you do with vinegar, as the old saying goes. So you're going to want to make sure that letter is not offensive and aggressive and just over the top. The second thing that you're going to want to do is that once that bad debt goes into arrears, you want to act quickly to get rid of it. The longer that bad debt stays on your books, the less likely it is that you're going to be able to collect that. You can see this statistic here on this slide. The chances of getting paid decrease week over week, and at the 6-month point, you're 50% less likely to even see that money. 25% less, 25%, so 75% less likely to get that money back after a year. So you're going to want to jump on that quickly and see if you can't get that collected. One way to do that is to consider using a professional. A lot of people are intimidated by using legal professionals for collection, but I can tell you that it's a fairly painless process. First off, attorneys who do collection work, for the most part, do that on a contingency fee, which means that they don't get paid until you get paid. So it's not costing you anything to hire the attorney. You may not get everything that you're looking for. You may not get 100%, but you're certainly going to get more than you would have if you hadn't tried to collect it. And when you get to that point, you have to remember that you're doing damage control at this point. You're just trying to collect as much money as you possibly can in order to mitigate the damage of the account receivable that isn't being received. The other thing that you need to keep in mind too about using an attorney is that, particularly in the collection arena, they're very heavily regulated. The Consumer Finance Protection Board is a watchdog governmental group that oversees and regulates collection attorneys, and they're very, very strict, and they're very, very meticulous about doing that. And then, of course, you've got other organizations like the BBB that are great watchdogs for that sort of stuff as well. But look at that last bullet point there. That's really the most important one, right? It takes this off of your plate, and it lets somebody else worry about it so that you can put your energy into where it needs to be, which is to say, running your business, right? You don't want to spend your time chasing money. That's that old adage of throwing good money after bad. You don't want to do that. You want to spend your time cultivating new relationships and building those business relationships. So let a professional take it and do the dirty work for you. Okay, so let's say that you do that. Let's say that you let the professional take over and they sue one of your customers and they get a judgment for you. Well, that judgment really isn't worth anything yet. It's just a piece of paper from a court that says that you have a right and entitlement to a certain amount of money from your customer. How do you turn that into money? Well, there are a couple of tools that you can utilize. First is the wage garnishment. This is particularly helpful when you have that personal guarantee, right? You have that the owner of the business has guaranteed that he's going to pay your bill. He probably draws a salary from his business, and you can garnish that wage. If the business shuts down, he's got to go out and earn a living somewhere else, so he's going to have to get a job somewhere else. So this is the easiest way to get paid if you know that your debtor has a job. States throughout the country differ on how much of the paycheck you're allowed to take, but most jurisdictions will allow you to take to up to 25% of the debtor's net pay. So what that means is that you'll send a garnishment to the court will approve it, and then send notification to that person's employer, and they'll peel your money out of their paycheck before they even see it. That's a really, really, really effective way for you to get paid. What else can you do? Well, there are other garnishments. They're called, very simply, garnishments other than wages, non-wage assets. That's the most common form to utilize, and one way is a bank account. That's the simplest way. And remember back to when we were talking about updating your forms and the credit app and all of that other stuff. If you got their bank account information, now you know where they bank. You know what the bank account number is, probably even. And you can send a garnishment to that bank account. You can freeze all of the assets in that bank account, and you can get them to pay you. I'll give you an example. I had a client once that was owed a substantial amount of money. They were a small business, construction business, and they had a subcontractor that didn't pay them. And so we garnished the subcontractor's bank account the day before he went on a vacation. And so he had to turn over and he had the money, and he had to turn over and pay our client because he was going to be gone for a week with his family and wouldn't have access to his money. So it's a real tool for small businesses to be able to put some leverage on the people that owe and the other businesses that owe them money. There's some other creative ideas that you can utilize too to get access to some of that. We've garnished credit card processors. So, for every swipe that on their Visa machine, you get a piece of that. We've had issues where we've gone in and just taken what's in the cash register. You can do that. PayPal and Venmo accounts are just like credit card processors. You can skim those. And really any asset that's of value, you can get after through garnishment or other means. And there's also the sheriff sale, which is how you would go about doing that, where the sheriff will go into the business and they'll tag things, and then the sheriff will take them into possession and sell them through a public auction in order to pay those debts. And then the last thing is a real clever thing that I've used in the past, is called a bank scatter, because a lot of small business people, particularly those that aren't so trustworthy that you come across, they know that you can get at their bank accounts, so they don't tell you the right bank account, or they don't tell you all of their bank accounts. So what I've done before is I've gone on the Google Maps and I'll map where they live and I'll map where their office is, and then I'll expand that region on the map, and then I'll search for all banks in that area. And I'll get a literal trail of banks from where they live to where they work. And I'll send a garnishment to every one of those banks. Who knows? Maybe you'll get a hit, maybe you won't. If you send a garnishment to a bank that they don't bank at, the worst case scenario is the bank sends you a reply saying, sorry, this person doesn't bank here. But if you find a bank that they had secreted away, well, you've just discovered another methodology for getting paid and infusing money back into your business. And keeping that money flowing into your business is extremely important, particularly in the atmosphere that we're living in right now. So when you get a judgment, you can also turn the judgment into a lien. So what is a lien exactly? Well, a lien is a security interest that attaches to a particular asset. It can attach to real estate. You can also attach it to personal property like automobiles and things like that. If you go through the proper processes, you can get your judgment transferred to other counties and to other states. So you can find assets and attach it to wherever the debtor might try to hide. So how long does it last? Well, that depends on the state. In Maryland, they last for 12 years and they're renewable for another 12 years. So you've got 24 years that lien can stay in effect. So if you get, let's say you get a judgment for $10,000 against a personal guarantor who owned a business, that judgment becomes a lien against their real estate. So it would go against their house, assuming that they own the house in their name alone. The lien would attach to their house. And then when they eventually go to sell their house, your lien gets paid just from you having done that. You don't have to do anything else after that. And that lien gets in line to get paid. Now, there'll be priorities in terms of who gets paid before whom, but you'll be in that line. And so what will happen is that when they sell that and the loan closes, the closing agent will have to peel that money off and give it to you directly. The debtor will never have it. They'll never touch it. It's a very effective tool. Another effective tool is the oral examination. In an open debt collection case, what you're allowed to do is summon the debtor to court and ask them to answer questions under oath about what their assets are. And you can take as long as you want and go as deep as you need to in order to discover where they have their assets. This is a very effective tool to motivate debtors to pay, because a lot of them don't want you snooping around their stuff. And a lot of them will strike a deal to try to avoid having you do that snooping. And the other part of it is if they ignore you and they don't show up, you can ask for a bench warrant to be issued, which means that the sheriff will go out and pick them up and bring them in on another day, which is a pretty effective tool. Nobody wants to be, out at lunch with a business colleague and then have the sheriff come in and handcuff you and take you away because you don't pay your bills. So that's a very effective tool as well. So let's shift gears a little bit and talk about some COVID-19 related challenges in this particular atmosphere. So what we've seen is that, collecting debt in the post-COVID world is very difficult, because one of the motivations for you collecting debt is that you need money that you're owed. Well, the flip side of that is that the person who owes you money probably doesn't have it, or is probably having a hard time paying it. So if you lean on them very hard, you could get some negative publicity. There's a public perception of debt collection that those people are generally bad or mean or cruel. And in some cases that's right, and you've seen it. In many cases it's not. But nobody wants to be perceived as being the character of Shylock from The Merchant of Venice. If you remember your Shakespeare, Shylock was the debt collector that wanted a pound of flesh, right? Nobody wants to be that person. So you're going to have to temper your debt collection with the possibility of negative publicity and what the public is going to perceive you, and how they're going to perceive you. The next COVID-19 related challenge is bankruptcy, right? Because if the debtor isn't paying you, they're probably not paying other people too. And what we're expecting in our industry is to see a significant uptick in bankruptcy filings in the coming year. And so what happens in the event of bankruptcy? Well, in bankruptcy, there's something called the automatic stay. And what that means is that as soon as somebody declares bankruptcy, all collection related activity against them ceases, period. Full stop. No, no ifs, ands, or buts about it. You have to stop your collection activity now. Under certain circumstances, there are some ways that you can restart that machinery and restart some debt collection activity, but you have to ask for the court's permission. And there are certain debts that are exempted from the automatic stay. That's a topic for a whole different discussion that's a little bit beyond the scope of what we're talking about here today. Just be aware that it exists. So here's another COVID-19 related challenge, and that's court docket crowding. And this is a significant problem right now. So right around mid-March, when the COVID thing sort of broke open, courts shut down. And since mid-March, and here we are, the beginning of June, so you had half of March, all of April, all of May, and now into June, and there hasn't been any court activity at all. Now, if you've ever been in a courthouse on just any given day, you see how crowded it is and how packed the court docket is. So imagine then for 2.5 months, nothing's happened except for emergency matters. That's a significant backlog of cases. What we've seen now is that the courts are saying that debt collection is going to be put to the back of the line once they restart court proceedings, which is going to start actually on Monday with a lot of criminal defense stuff, bail review hearings, bond reviews, and violent crimes, drug-related offenses, alcohol-related offenses, and things like that. And so one of the challenges that you're going to have is if you decide to hire a professional, it's going to be hard to get that into court quickly. So you may want to try to maybe guide that more towards settling, more toward trying to strike a deal with your debtor to see if you can get some money inflowing sooner rather than later, because in that case, it might be a matter of getting the money faster versus getting more of the money later. That, of course, is going to be a business decision that you yourself are going to have to make depending on your own liquidity. The other thing is that there are moratoria that have been placed on collection activity. A lot of clients just simply don't want to go forward with collection, but there's also pending legislation, and this is where it gets scary for small business owners, because legislators don't really understand how accounts receivable and debt collectors work. They don't really understand how small business operates, which we saw with the PPP loan and all of the problems that have come out with the PPP loan and people not getting enough money or not getting money or not being allowed to use the money for the right expenses because you're only allowed to use it for rent and payroll. You can't use it for vendors and supply chain issues and things like that, at least not yet. So some legislators have instituted some legislation that I would suggest everybody on this call pay attention to. What are they? Well, here they are right here. House Bill 6321 that was sponsored by Maxine Waters. That's one of the more dangerous ones that I've read because it requires a complete moratorium on all debt collection, period, for a very long period of time, which I'll talk about in a minute. Senate Bill 3565, also very dangerous, sponsored by Sherrod Brown, Cory Booker, and Elizabeth Warren. That also suggests a complete ban on all debt collection. House Bill 6423 from Al Lawson. And then there's the HEROES Act. Now, the HEROES Act, House Bill 6800, is a little bit more level-headed in terms of how it's treating debt collection. And that one might actually pass, and that one won't be as bad as the other three. But why are they bad? Well, here's why they're bad. they're well intended, because what they're trying to do is they're trying to protect citizens from debt collectors, right? They don't want debt collectors to take money from people who need money when they need it the most. That's a very well intended objective. But what they've done in drafting it so hastily is they've handcuffed small businesses, because not only will small businesses not be able to collect against individuals, but they won't be able to collect against other small businesses either. And that's going to have and that is unintended in the legislation, and that's going to have that's going to place a tremendous financial strain on small businesses. It's also going to include existing lawsuits. So anything that you've got in the pipeline now, it's going to come to a full stop. Now, what are the other problems? Well, there's no analysis of whether the debtor has suffered any actual financial harm based on the COVID-19 and COVID-19 related issues. There are some businesses out there that are flourishing right now because of the pandemic. Is it fair that they could shirk their bills and not pay them, or more particularly, is it fair that they don't have to pay you what your small business is owed just because of this legislation? And there hasn't been really any thought about that. The duration is also something that is a problem. Most of this legislation is placing a moratorium that will last as long as the duration of the declaration of emergency plus 120 days. Okay, so 120 days, what's that, 4 months, right? So how long could that be? Well, let's talk about that for a second, because if you remember the SARS breakout back in the early 2000s, that SARS didn't become a global pandemic. It was an epidemic that was locally contained, primarily in Asia, with a little bit in the United States. There was a declaration of emergency for that lasted 18 months. 18 months just for that. And that wasn't as nearly as prolific. It didn't do as nearly as much damage as the COVID-19 is doing. So to have it last for the duration of the emergency plus 120 days could place moratoriums on debt collection for years, which could be devastating, not just to your small business in terms of its ability to collect its own debt, but it could be devastating to you in terms of your ability as a small business owner to get credit from a bank, credit from another vendor, because nobody's going to extend credit to you as a small business if they believe that they're not going to be able to collect that. And so you're going to see small businesses failing because they can't get the supplies, or they can't get the cash to buy the supplies that they need, because people are afraid of being unable to collect what they're owed. Again, an unintended consequence of a very well-intended bill that I don't think that these legislators are really thinking about or aware of. And then finally, the thing that is potentially dangerous is that it amends the Fair Debt Collection Practices Act to include commercial debt. Now, the FDCPA right now is a very strong and very good piece of legislation that protects consumers from unfair debt collection practices. To put those kinds of restraints on commercial debt would restrain commercial trade so much that it would, again, make it difficult to get credit as a small business. It would make it difficult to get cash, to get any kind of liquidity, to get what you need as a small business owner. So this legislation is very, very dangerous for those of us that own small businesses, and the legislators aren't thinking about that. And I know this from personal experience, based on what I'm about to tell you on this slide. So what can you do? Well, one thing you can do is follow the legislation. If you go to that govtrack.us website, you can follow the status of that legislation. But more importantly, what you can do is contact your government representatives. There are two links on the screen there, one to find your representative in the House and one to find your representative in the Senate. And I can tell you from personal experience, I've done this. And these legislators are listening. This isn't a situation where you're just going to put an email into a legislator's website and then not hear or know anything about it. I can tell you that I contacted my representative, who you all may be familiar with. It's Dutch Ruppersberger. And within, I would say, I think it was like 4 days, I got a phone call from a legislative aide from Dutch Ruppersberger's office addressing my concern and talking to me personally about what that concern was and what his position was on it. And that was with respect to that first bill that I showed you right there, the 6321 for Maxine Waters was the one that I was particularly concerned with when I spoke to the legislative aide. So they're listening, particularly right now in the atmosphere that we're in. Our elected officials are listening. They want to hear from you. As a small business owner, I think it's all of our responsibility to make our voice heard. Because it's very dangerous out there right now for us from a financial standpoint. And if we don't make our voices heard, these unintended consequences could do significant damage to all of our respective businesses. So I would encourage everyone to reach out to your legislators and just make your voice heard. And that's it. So I left a little bit of time, as I know we're booked for 45 minutes. I left us, we got about 6 minutes for questions. So if anybody has any questions, I would be happy and pleased to answer them.
Awesome. Thanks, Bill. I'm going to keep an eye on this chat bubble. And in the meantime, I'll also go back into my email to see if anybody sent Better Business Bureau an email with questions. But for everybody in the chat now, if you're logged in a computer, feel free to leave a question in the chat. All right, and I don't see any in the email.
Okay.
Here comes one.
Oh, thank you very much. It's my pleasure.
All right.
Nice shout out.
Well, thank you everybody for attending. You'll be getting a follow-up email that will have the recording and the slides from today's presentation. Thank you so much, Bill. It was certainly fantastic information that's very useful for business owners nowadays, as always. So, all right, everybody, have a great day, and we'll look forward to seeing you on another Trust Talk coming up.
Thanks, everybody.
Bye.